So after that, we will see now the historical school. Let's continue with the historical school. And that is the school, a school of understanding, a thought that to understand what is the law. And the first author that we will see today is Friedrich, of this school, is Friedrich called Carl von Savigny. Savigny, don't you remember that name? I mentioned that name just once when we talk about Germany, but they didn't have immediately, they didn't approve immediately the civil code. I said because one guy decided no, it's not good to have the code now. We have to wait. So this was a professor of jurisprudence, a very powerful, very clever mind of jurisprudence, and he realized that well, the study of the law was very abstract, and still today, especially in the civil law system, is changing, especially in the last 40 years, it's changing. But what Savigny said, well, French people are studying just what is written in that book, and they don't know, they have no idea about the past. Why this line is written in this way? Why? Well, because there was a custom, there was a way of doing things in a certain way that now is in an article. That is nothing new. So we shall study the law in more in an empirical way, with an empirical method. And that's why to understand the law, we have to understand the history of the legal system, the history of the country. And one research that he did was so successful in Germany and also in Europe, I think so. It was called, the title, Das Recht des Besitzes. So is Recht, the law, the law about possession, the law about possession. He showed 1/4 of the French code. The French code had many incredible things, well done, but many others not that well. And one of the weakest parts of the code, of the French code, is the regulation related to possession. I remember that I have many cases about possession, a problem, just to mention, of land that two parties discussed 50, 60 years, a discussion, 21 cases using the French code, more or less, that is more or less the same in Ecuador, my country, in South America. There was a lot of problem. So this guy at that time realized that there is a lot of gaps in that code, in the regulation related to possession. And he wrote a marvelous article. He said, well, you, France, are so proud of your code, but look, you have this gap. And if you compare this, because he studied a lot of history, Roman Empire history, and how was the law in the Roman Empire, you compare your code with the Roman regulation of the law, you will see that you are not the best one. You shouldn't be proud of yourselves because you have a very weak code. Was so successful, that article, no? Because everyone understand at the time that if we really want to create a good code, first we have to study history. First we have to understand our history. It's not just a matter of, well, this is reasonable and this is the code we have to read and to understand and done. More or less, the labor of the judge was more or less, no? Understand the code, put the facts, and get the conclusion. No, he said, no. It's not a syllogism. It's not, the positive law is not a product of reason. What is a product of our culture. That is not exactly with that word, but one example that was quite interesting, he said, well, language. How was created our language? Well, obviously not by a decision of a guy that say this will be the word and this will be, and you cannot use that. No. Language was created in quite different way, in a continuous and organic process of a nation that, and their customs, and when they realize that they need a word because there is a new thing, no? I don't know, probably the new technologies, no? WhatsApp is WhatsApp in every language. In Kikuyu, how do you say WhatsApp in Kikuyu? Probably WhatsApp, I don't know. Or in Luo, or in any other language. Well, when you need one word, we can create. But let's use the same thing that we had in the past. So the language and the law should be created in that way. The customs and the problems and the culture of every country. So he focused his attention in the Volksgeist. Don't you know what is the Volksgeist? It's German. You should pronounce that in that way. The Volksgeist. No one of you, so don't worry. The folk, well, that's the same in English. Hey, folks, how are you? That is folks, more or less the people, no? Geist, spirit, the spirit of the people. So you should know that at that time, previously in the time of Napoleon Bonaparte, there was a strong rationalism, but not is that things should be rational, but everything put in order, and you should conclude that, and there is no space for error, and so everything. But as a reaction of a century of rationalism appears Romanticism. And Friedrich Carl von Savigny was a romantic. By the way, not a romantic that he was always falling in love with someone. No, not in that way. Not in that way. Romanticism is a little different. That movement, philosophical movement, Romanticism. So they believe more or less in the spirit of the people. The spirit of the people. So the law should be not that way, so rigid, no, in a code, no, but should be the spirit of, well, let's see what we have in our hearts, no? That is, and everything, man. So there's a lot of novels of that time, romantic, also with love, but also with nostalgia and many other things. The remember of the past and many other things. No? Well, so the Volksgeist at the end of the day is a common consciousness of the people of a country. Yeah, it's not a common in the whole universe, in the whole humankind. No, it's of the people of a country, the spirit of each community is more or less, no? And if you want to know what is the law, well, you should study that. Where you will find that? Well, that is represented by the lawmaker and the academic jurist of that time. So why is so important this? Because he understands that to understand the law, we have to understand the history, the culture, the language of that one country, more or less, not to understand the law better. There are a lot of rules and a lot of consequences. I will give you just one. For example, the historical interpretation of the law. The historical interpretation of the law checks what is the history of the law in that country. And the example is in my country. There was a big crisis in the year 2000. A big one of the, perhaps, well, I don't know if the worst one, but 1 million people leave the country, yeah, because that crisis. There was a great inflation. If you have, for example, $1,000, well, sucres at that time, the currency was sucre. The next month you will have the third part, and the next month the third part, and you will lose everything. You will lose everything that you have in your account. So that's why many people decide we are a small country, only 16 million. A million to lose is 5%. I don't know, a little more perhaps, of the people of the country going away because of the crisis. No, so they decide, and the Constitution said the official currency of the country is sucre. That is the name, sucre, as here, Kenyan shillings. But with that crisis, what they decide? Well, in the year 2000, they decide, let's approve that the dollar is the new currency. But you cannot put that in the law. The dollar is the new, no, because the Constitution said, the Constitution, the sucre is the official currency and is the only one allowed to circulate in the country. So the law just said, well, from today, it is also possible to use dollar in any legal transaction. Also, but that day, no one used it against sucres. No one, because they will know that they will lose their money. So, and you can say, no, but the law is so clear. The law never banned, never prohibited anyone to use sugar, but everyone in the country, because they were living the history of the country, realized that the sugar no longer will circulate in Ecuador. And that happened. So with a historical background, you can understand better a law that seems to be so clear, but at the end of the day say quite different things that are written. Okay, so that is the historical movement. And that is why precisely he was against the codification. He said, we need to wait to understand better our customs, our culture, the Volksgeist of Germany, and then we will have more background to approve one code. And that happened. They wait almost a century, and after a century, they created many things, many ideas. There were great jurists, Winshade, Pukta, and many others, and created marvelous things. I think that after 1 century, they approved the BGB, that includes so many theories of the legal business and many other things that probably you are using also today here. Some of them, that ideas and around the world. So you have two main traditions in the civil law system, two main traditions. The French tradition, that is in many places, also in Japan, for example, and the German tradition, because after that many countries follow the German tradition of civil law. So now you know you have another idea, no? How it's split into the main traditions in the civil law system. Because that guy, Friedrich Carl von Savigny. Okay, let's see another. If you don't have any question of this guy, let's see another one. This is Sir Henry Maine. Sir Henry Maine is Sir. is from the UK. The historical movement was not so deep in the UK, but you find some authors as this one. He explained more or less the history of any kind of laws around the world. That is his theory. I don't share that theory 100%, by the way. I'm just showing what the author said. Okay? So he said that everywhere in the world, every country, the history of the planet Earth approved their laws in some stages, some phases. The first one was the law made by the ruler under divine inspiration. The law was made at the very beginning, well, and that is more or less clear in some countries of the antique countries, no? On the antique Greece, not the latest one. The antique Rome, not the latest one. Well, the latest one also in Rome, because Caesar was identified with God more or less at the end. So at the end and, and at the beginning also. So the law is more or less as related to God, or to the gods. Then there is a period of customary law, custom that create the law, and after that the third phase is the knowledge of law in the hands of priests. In Rome, you have many priests that also say this is the law, but it was not so clear in Rome. In many other countries, probably could be similar. I mean, in the indigenous people of America, in the indigenous people of some country here, probably could be, and also well, in Europe in a different way, because any university, the university system was a convent of nuns, of priests and monks, that they teach a lot of things, in the convents, in the convents, and that was the origin of the university in our history, I mean, in the world history. That's why we have the university. So that was taught on by the priest. And final, according to this, the final step is codification. So he said, remember, he was in the UK. In the UK, the historical movement was not so deep, neither the codification movement. The codification movement at that time was an explosion around Europe, but not in the UK, because they have very different things, very different problems at that time. Well, they had a lot of rights approved, the Bill of Rights, the Habeas Corpus Act, and everything. So they didn't realize that they need another thing. So there was also a mention in the French Revolution of the social contract by Jean-Jacques Rousseau. And before Jean-Jacques Rousseau, Hobbes, and after Hobbes, John Locke, and many other authors, no, that talk about there should be a social contract. It's a hypothesis, a hypothesis to understand what is the law and how is the legal system, and was not real, obviously. And the critique of Sir Henry Maine say, well, the social contract, you cannot find any social contract on history. Well, probably in Greece cities, yes, in the polis, Greek polis, yes, but well, he didn't know that. So why? Because individuals lacked the capacity to change their legal status or acquire duties until much later. What it means? Children cannot sign any agreement, children. If you're minor, well, you don't have the capacity to sign anything. And why you can say no, they are part of this social contract. So that is not, on the other hand, the adults, no, you. Where did you sign the social contract? No. Where did you sign in the Constitution? I approve the Constitution. And finally, what happens if you don't approve that? You say, I don't want this social contract or this legal system. You also bind it. You are also binded under this legal system. So he didn't believe in the theory of social contract. There are many theories, as you know, many theories. But he said, well, that theory is false. It's not good. What we have to see is what is real history, not what it is myth, not what is unreal tales. No? So the common ownership was the earliest form of title. Yeah, he said also that. Well, the communist movement, the beginning of the social ideas with Marx. He followed more or less, and specifically for the law, that is could be interesting. He said that fictions are one of the most important parts of the legal system. Many authors, Blackstone, for example, also said that fictions are the most essential part of the common law system, Blackstone, of the common law system. So they realized that fictions, what is a fiction? For Maine is an assumption that changed the rule. Let's put one example, adoption or two. You treat someone as if that one is your son or your daughter because you adopt, you recognize him in a legal act as your son. But obviously that is a fiction because that guy doesn't have the same blood, the same DNA, the same origins. No? Obviously, the fiction, any fiction has its limits. So, for example, if in many places is you have one children and one is adopted, and the adopted wants to marry the other, probably it's possible because they don't have the same blood, they don't have the same origin. Well, there are many possibilities, but probably it's possible. Okay, The same happened also with the Roman citizenship. Many people that were not Roman, they bought the Roman citizenship because with that they will have a lot of privilege. One of them, you cannot have certain kind of punishment. You cannot be scourged. You cannot be crucified. So many people bought the Roman citizenship just to avoid these kind of things, no, to have some privilege. But obviously they were not Roman citizenship. They bought that. So that is a fiction. Against of that time, Bentham was said, no, fictions are not good for the law. Against Henry James. Maine, he said, fictions are to law what fraud is to trade. We will see a little more of Bentham next week, I think so, but it's good to understand what they think about. Okay, so with this we finish